up to like $7,000 worth of damages for the house, and it wasn't no damages. And I was so confused about that because I didn't do any damages to the property.
Purposely cut. They weren't just messed up. These were like the court judge granted me the damages.
My decision, based on what I'm hearing, nothing to do with what the magistrate judge heard. Okay. Don't care.
Well, this is a lesson learned here in Georgia because it doesn't work like that in California.
No, ma'am. But that's the problem. Everybody comes to Georgia thinking it works like it does up north, where it's no, right. It does not. Well, so, Ms. Leek.
Yes, ma'am.
So this is the case 2024-CV-02018. This is an appeal from magistrate court for a dispossessory. Is that correct?
Yes, ma'am.
All right. So are you still in the property or have you left the property?
I left the property. She had gave me 60 days to leave.
Okay. So this is an appeal as to a judgment.
Yes, ma'am.
All right. And Ms. Moore, you have possession of the property. Is that correct?
I do.
All right. All right. So go ahead, Ms. Leek, and tell me what is going on. It is my understanding that there was a damages amount of $4,575 from the magistrate court.
Yes, ma'am. So I was living in the property for 6 years. The previous owners, one of the wife had passed away. So the husband sold the property. Mm-hmm. However, Ms. Mora allowed me to still stay there. She gave me a lease for 6 months and the price of $70.75. And if I needed more time, I can stay there. So came January, I still needed more time. She let me stay there for another 6 months without a lease. But she told me that she would charge me $1,100, which was fine. Came July of 2023, Ms. Mora told me that she was going to, I guess, reconstruct the property. And that I had 60 days to move out. Let me back it up. Prior to me moving in there in 2017, I moved in the property as is, meaning that the carpet was old. I got it clean. No new painting. The appliances was very outdated. Countertop, very outdated. The owners at the time let me do the countertops over. I did carpet cleaning. I wiped the walls down, fit enough for me and my daughter to live in. Okay, so let's go back to July of 2023. When I was told that I had 60 days to move out, I went and go seek housing for me and my child. And I wanted to hurry up and do it before my child went back to college in August because I knew I was going to need the help. So I found something. The agency told me that I would have to pay, the deposit to move in. I did that and I went straight ahead and moved out. I had a week to move out because my daughter was going back to school. And like I said, I was going to need the help. Ms. Mora still wanted me to pay the rent there. So I told her, hey, I had the money to move out. I didn't have the money to pay you another month of rent.
Okay.
You already gave me.
Hold on. Okay. Slow down for me because I need to understand. So Ms. Mora gives you a 60-day notice to leave.
Yes, ma'am.
Okay. And how long after that did you move out?
I found something in the beginning of August. So it was like maybe 30 days. Within 30 days, I found a place.
So what was she charging you for?
She wanted to charge me another $1,100 for another 30 days. But like I said, I didn't hit.
Ms. Mora, you asked her to leave. You gave her a 60-day notice, which is required when the person doesn't have a lease, but they're working under a previous lease or the previous lease terms. The landlord is required to give a 60-day notice. And within that 60 days, if the person leaves, why would you then charge her for an additional month?
So there's gaps in her story. So do you want me to say my side of the story? Or do you want to finish until she says it? Because that's not exactly how it all went down.
Okay. Let me hear the rest of Ms. Leek's story. Okay, Ms. Leek. So August 2023, you find the new place, and you said Ms. Moore wanted you to pay another month.
She wanted me to pay from August to September.
Okay.
Another month of rent. So the money that I had to move was to move because I had to move because I didn't want to be homeless within the next day paying her and then trying to pay a security deposit for a new place for me to stay.
Okay.
So as I was moving, I'm trying to hurry up and do everything. And she had reached out to me like, hey, you haven't paid the rent. And I'm like, oh, hey, by the way, I found a place. Because prior to that, she had
Hey,
signed
let me
for
ask you
me.
this. Had you
Mhm.
paid the rent for July?
Yes, ma'am. I paid the rent for July.
Had you
And
paid
she
the rent
also,
for August?
I didn't pay no rent for August.
But you were still in the place in August?
Well, I had moved out. I had moved
When?
out August the 5th.
August 5th.
Yes.
Okay.
Yes. So she had signed as a reference for me for my new place. So she already knew that it was getting close to the work because she had signed it for me. So August the 5th, she reached out to me and she said, hey, you haven't paid the rent. And I was like, oh, I got the place. I'm just talking to her because she was so nice to me the whole time I was there. I'm like, I got the place, like excited, because I know I don't have to wait and figure out if I'm going to be homeless or what the
Okay, I
case
got
was
that.
going to
But
be.
did you move on August 5th or you moved
Yes,
after?
I did. I moved. Yes,
So
I
all
moved
your
out.
stuff was out of the place.
I got everything out there the same exact day. I think it was the 6th. I'm sorry. The 5th and the 6th. Yes, ma'am.
Okay.
So rent is normally due on the 5th of the month.
Okay.
And I moved everything and she was saying, well, if you don't give me the money by this time, I'm going to have to take you to court. I'm like, well, I had to move. Like, I didn't want to be homeless. I wrote her a letter and everything like, hey, this is what's happening on this day of August 2023. I wrote me and my daughter, we both signed the paper and said that we was moving out the place. I found the place. I knew you knew it was coming because you gave me 60 days and also you saw it as a reference for me to move into, so I can go to the next place. And it got approved. And then after that, I had got papers from the court saying I had to come to court. And it wasn't even for the $1,100. It's like she wanted me to do remodeling on the property. And I was so confused about that because I didn't do any damages to the property. When I moved out, I took everything out. I cleaned everything. Anything that was left in there was stuff that was from the prior landlord that he had there when I moved there. And I didn't touch it because it wasn't mine. But like I said, appliances outdated. The townhouse was outdated. I just made it fit for me to live in. I can't hear you. Went out.
I'm sorry. What else happened?
And then
the court.
I got the papers for me to come to court.
Okay. And what was she claiming were damages that you had to pay for?
She had it on there for like the appliances. I can't recall everything they had. The court said they was looking everything over, but basically it was like up to like $7,000 worth of damages for the house, and it wasn't no damages. No.
Okay, were there holes in the wall?
No, ma'am.
Okay, did she allege that you had put holes in the floor?
It wasn't no holes in the floor. I don't know where her
Was there
damages
copper
came
missing?
from. Nothing missing.
Light fixtures?
Nothing. Everything was still as is. I moved in 2017.
All right. And how much did the court grant in this case? 4,000. What now?
No, the whole thing was like 7,000 and something. I don't have the whole dollar amount, but I know it was over 7,000 versus me paying $1,100 for a rent for 1 month.
All right. Okay.
And then she also had security deposit that the prior landlord gave to her from me after he gave her a reference to ask if I can stay into the property.
Let me ask you this. So with the security deposit, did she give you the opportunity to do a walkthrough with her so she could do a list of all the things that were damaged?
Were you saying a walkthrough the last day or
No.
walkthrough when you bought the property?
When you told her I'm moving, did she send you notice that you could do a walkthrough of the property with her?
No, she just sent me a message saying that.
Did you ever receive a list of damages from her prior to coming to court?
No, ma'am.
Okay. So then she used the security deposit that you had as damages in this case?
I think when the court summed it up, they had put the security deposit in there and minus it from what she was asking for.
Okay, and how much was the security deposit?
It was $775.
All right. So let me ask you this. So did she ever send you a notice to either your address at that place and it got forwarded to you, or to the new address that you had the opportunity to walk through the property with her to determine if there was any damages?
No, ma'am.
Okay. And did you receive anything from her after you moved out that said, these are the damages I walked through and saw, so this is how much of your security deposit I'm going to keep?
No, ma'am.
Okay. All right. All right. Is there anything else you want me to know?
No, ma'am. That'll be all.
All right, Ms. Mora.
So I just, I'm kind of flabbergasted by what was stated. Nonetheless, I don't see that a judge would have granted me the
Ma'am, I
amount that
used
I
to
was.
be in magistrate court. A lot of judges don't know about the security deposit. And if they don't look, they might not realize it. We're not infallible. But under
So I
section 44-7-33, there's an actual procedure by which you have to go through to document damages, to keep her security deposit, to determine any other damages.
I did everything as the Georgia law stated. So on July 7, 2023, she was provided a 60-day notice. It was emailed to her on that date. It was certified mailed to her. All these docs are actually in the file that was submitted on the magistrate court. And also the hard copy was also put in her mailbox, which also I have pictures of.
Okay.
So this was all provided to her. And as you can see on the file, I have the hard copies here as well. So this is a 60-day notice that was given. This is the courtesy email notice that was given to her. And this is the certified priority mail express that was delivered to her door. And also I went and drove over there and I also placed it in her door.
Okay, so she's not arguing that you didn't give her the 60-day notice. I think she's, her argument is about the damages.
Right. And so furthermore, on the email, I also stated a move-out inspection is optional, must be requested in writing, and must be completed 7 days prior to September 5th of 2023. The $750 security deposit per the rental agreement is to be returned within 30 days rental agreement has terminated. Less any damages, security deposit shall not be credited towards rent unless the landlord gives written consent. 60-day notice to vacate is attached. I will stop by the property this afternoon before 1:30 and hand deliver you the notice. If you are not at the property, I will make sure to post it on the door. Lastly, the 60-day notice will also be mailed first class. So this was provided to her via email. To the
And what was the
email
date at which she had to do the move-out inspection? Give me that part again.
September 5th
Okay.
by 2023. I gave her the 60-day notice on 7/7, right?
Okay.
It allowed us ample time to do it September 5th.
Okay.
So she never responded to the move-out inspection. I then get a text message on August 6th stating that she's moving out of the property. I told her that I provided her with a 60-day notice, and per our agreement, it clearly says on here that this agreement shall be month to month beginning on July 7, 2022. At the end of any time, the landlord or tenant providing at least 60 days written notice to other parties. So I gave her the 60-day notice. Not one time did she convey to me that she was going to move out prior to those 60 days. How she conveyed that to me in a written notice, then I would have been okay with that.
Ma'am, I think you're confused. So you're saying I gave her a 60-day notice, and in your mind, she wasn't supposed to move out until the 60th day. But that's not how this works. If you give her a 60-day notice, she's required to have 60 days before you can take any legal action to remove her, such as bringing an eviction. But it doesn't mean she's bound to stay in the property and to pay the rent for 60 more days. It just means that's the amount of notice that she needs to give, that you need to give her prior to taking any action. You got me?
Right, I understand that.
So when you say she got 60 days and she never told me she was moving out before the 60th day and I want her to pay this last month of rent, it doesn't work that way. And you
So
say that y'all had a written agreement for her to stay. That sounds like a lease.
we did have a lease.
Mm-mm.
But
There's
in
a
it,
lease
you
agreement.
agreed that each of you would have, instead of 30 days, you would each give each other 60 days notice. That's the only change to the lease. You just said we had in writing that I would give her 60 days notice and she would give me 60 days notice.
I never said, I'm sorry, no. So the lease
Reread what
agreement
you
is,
just said.
the lease agreement is here. This is a month-to-month
Ma'am,
lease agreement.
I get you can't have a month-to-month lease agreement. Either you have a lease or it's month-to-month. You can't do both.
It's a
Month-to-month
month.
means no, ma'am. You got something in writing. Month-to-month means nothing in writing. We're traveling under the old lease terms, and it's year to year or until I give the 60 days notice or she gives the 30 days notice. That's month-to-month. Lease means y'all sat down and talked about this, came up with some agreement and wrote it down. And you have from from July of 2022 to July of 2023, there's an agreement in writing. You just said.
So I guess that's my error. So this is considered a month-to-month. So
No, ma'am, you can't say that. If you have a writing, if you have a written document, it's not month-to-month. You have just given her more time than you would generally give her to move out. You gave her 60 days. See, this is what happens when non-business people try to do things legalistically and they mess themselves up. So I'm listening closer because I did 4 years in magistrate court. I have combed through every part of the dispossessory code and I teach it at new judges training. So when I tell you, you can't say to me, it's month-to-month, but we have a lease or a written agreement. It's one or the other. It can't be both.
That's fine, and I'm not going to harp on that. That's fine. However, because I'm really, the court judge granted me the damages. So
okay,
when I took,
but I get to look at it de novo, which is Latin for as if everything is new. I get to hear all of it, and my decision based on what I'm hearing, nothing to do with what the magistrate judge heard.
okay.
Don't care. Okay.
Gotcha.
So
okay.
But I would suggest as a business person that you sit down with a lawyer who is knowledgeable about dispossessory law and clear it up, because you're talking about month to month with written lease terms. That's not how this works.
Got it. Right? Thank you. Thank you.
Now let's get back to the damages, because really she's out of the property, so all of that is under water under the bridge. What I need to know is whether you gave her the opportunity for inspection. She moved out earlier than September. Was there an opportunity for her to inspect when she moved out? Like, did you send her an updated notice?
No, I did not send her an updated notice. She texted me, and the text said that she will go ahead and vacate. She's vacating, and then she will leave the keys in the mailbox.
Okay. So at that point, when you knew she was vacating, did you say, hey, I'm going to do a walkthrough? Because presumably if she's out in August, you're going to try and rent before the September. You're going to try and get somebody in there. So she's not going to do an inspection with somebody else in the property. At that point, did you update your notice to her about the inspection?
No, I did not. There was no further communication, but through the courts when I went ahead and filed. So there was no further communication.
Okay. And then when you went in and decided all of these things that you were going to seek as damages or that she needed to repay you, did you send her a detailed list of all of these things before you went to court?
There was no forwarding address.
No, ma'am. It doesn't matter, because the law says you send it to the last known address. You let the post office worry about whether it gets forwarded.
Got it.
So
no,
you're talking about how you did everything by the law. The law says you can use the last known address. If it gets forwarded, it gets forwarded. If it doesn't, it doesn't. But did you send any communication?
No, there was no further communication.
Okay, now tell me about all of these things that you feel like she should have paid for when you bought the house as is.
Okay, so I bought the house as is, and I did do a walkthrough with her. At that time, there was no pet. She had a pet in there. There were holes.
Okay, hold on. Did you document the walkthrough that you did with her when you first came in and she was attorney to the lease? Did you document it?
I did document it. I
Did she
did a
get a
move-in.
copy of it?
I sure did.
Okay, did she get a copy of that?
She signed it.
Okay, but did you give her a copy of it?
Via email? Yes, I did.
Okay, so now tell me when you walked through after she left the property, what did you determine she should have paid for?
Okay, so there's holes in the window screens, right?
Okay.
There were cut out blinds, as you can
There were
see
what?
here in this. Hold on, I'm trying to get it
Blinds.
so where you can see it.
Okay,
They
so
were
the blinds were messed up. Okay, next.
purposely cut. They weren't just messed up. These were
It was
like
mine.
Okay, go ahead, Miss Mora.
The blinds were actually cut. The window screens were completely off on all of the rooms. You can clearly see that they were holes. There were dog bites at the bottom of the blinds. This is the sliding door blinds. There were dog bites at the bottom.
Okay, did you tell her she couldn't have a pet?
It was written into the agreement or the month-to-month.
It's the lease, ma'am. It's not a month-to-month.
Sorry. So the lease.
And she was not to have a pet.
She was not to have a pet.
Okay, what was hold on. Slow your roll. Okay, if she had a pet, was there a penalty that she had to pay?
Yes, there is. It's right here. $350 pet fee, $350.
Okay, a one-time $350.
Yes.
Okay, go ahead.
Okay. So there were. Hold on, I'm looking for the closet doors. There were glass. Both of those were cracked. I don't know if you can see that well, but they were both cracked. And all of this stuff was submitted. As you can see, the door knob on one of the bedroom doors would look like it was kicked off or kicked out from the thing. Hold on just a second. The electrical outlets have been damaged. There was paraphernalia found on the apartment.
What do you mean paraphernalia?
Paraphernalia. There were Swisher wrappers and marijuana found in one of the kitchen cabinets, which I have a picture of. This right here is a smoke detector
how does the marijuana paraphernalia damage you?
It had to be cleaned out. It had to be disinfected. All of the.
I hate to say this, but have you owned rental property before?
Have. Both here in Canada.
Listen to me. Have you ever heard of turnkey costs?
I have, but because of the odor, they have to do a special treatment for that. That's just like when you rent a car.
What I'm saying to you is I'm real familiar with rental property. Don't ask me how I know. Real familiar. But turnkey costs on average are from $3,000 to $5,000, depending on how long the person lived there. Generally, carpets need to be replaced, floors need to be redone, painting needs to be redone. Certain things may have to be replaced, doors, windows, window screens. So all of this stuff that you're claiming is under the list of things that have to be done to turnkey a place to put somebody new in there. I don't know how you feel like this is not a cost that the landlord should bear.
All of these damages that I just pointed out, like
yes, ma'am. Because when you talk about window screens and blinds and stuff like that, that's normal wear and tear for somebody who's lived in a place 6 years. Window screen and blinds, those little blinds, you're buying rental grade blinds. You didn't buy them, but the previous people did. you're not buying high-end stuff. You're buying rental grade. And when you buy rental grade for a rental property, it needs to be turnkey. So all of this stuff it seems like you're taxing her for something that, first of all, the people who did it the first time this was not a high-end property. Some of that stuff she may have purchased out of her own pocket as an agreement between her and the previous owner. You don't know because you took over after she took the property. How long was she in the property, Ms. Mora, before you took over?
That I don't know.
How long was she in the property, Ms. Mora, before you took over?
I don't know.
Okay, so you don't know if any of that was purchased out of her own pocket.
It was not, because when I did the walkthrough, she never spoke upon it. She never spoke in regards to any repair that she had done. The repair that she did was to change a toilet valve inside, which I reimbursed her for it. Thereafter, she did not point out anything that needs to be repaired. You cannot justify having a hood range to like this after I did the walkthrough. You can't justify my smoke detector being uninstalled. You can't justify the cabinets. You cannot justify the warped cabinets after I did the walkthrough and that was not on there.
Okay,
Regardless, what was that?
Damage to the cabinets. Did she report the reason for the damage to the cabinets?
She did not report absolutely nothing from the time that I did the walkthrough with this lady up until the time she moved out. The only report that she made was a toilet valve that she replaced, which I still have the text for that. And I went ahead and credit her for her purchasing that.
Okay.
So time after I did the walkthrough was my stuff looking the way it came out to look after she moved out.
So how much did you spend to turnkey the property?
What's that? I have all of my individual receipts. Let's see. It could have been, basically it was around more or less whatever I put the amount for when I originally did the court claim, which was, I think it was close to right here it goes, $7,410. That's what all of my receipts added up, and I also asked for the court costs to be reimbursed.
Okay, and you kept the $775 security deposit.
Correct.
Okay. All right. What were the most expensive items that you had to replace?
The most expensive items, let's see, hold on, I have my receipt. The bathrooms.
Mm-hmm. What did you have to replace in the bathroom?
The carpet, I understand that's prorated because she was in there. I also replaced the carpet.
Okay, no, carpet is turnkey, ma'am. I'm not giving you anything for carpet.
Right, that's fine. So basically it was the kitchen area.
What did you do in the kitchen? What did you do in the kitchen?
Do all of the cabinets, and I have pictures of all that.
What do you mean do all of the cabinets? What do you mean do all?
The cabinets warped. All of the doors and the inside of the cabinets that were warped with the stuff that she left behind there, and also the bathrooms. The bathrooms were the same thing. The bath, I had to replace them. I had to replace the toilets. I had to replace the kitchen countertop. I had to replace I don't know if this is included on the turnkey. I had to replace all the appliances. I had to replace the refrigerator, everything you can think of. This is the stove top where she left. It was literally burning a hole onto the dripping pan on the stove.
So you can buy dripping pans separately. Those are about $4 or $5. So why did you have to replace the entire stove top?
Because the stove top, let me show you what it looked like. This is why I had to replace the dishwasher because it was not working.
Okay. Ma'am, Ms. Leaks, how long did you live in this property?
I lived there since 2017.
And Ms. Mora, how long did you own the property?
I purchased the property on 2022.
And did you put any new appliances or anything into the her living unit when you purchased the property?
I did not, because there was nothing.
No. Listen to me. Listen to me. Did you paint when you moved in, when you purchased the property?
No, because there were
Did you
no
replace
damages.
Did you replace the flooring when you purchased the property?
No, I did not, because there were no visible damage
Okay.
at that time.
So at this time, you've already received the $775 for the security deposit. Ms. Leaks owes you $350 for the pet damages. And the rest of that is turnkey, because you would have had to do, she's been living in that place for 6 years. When you bought it, it had all of those old appliances. It had the old fixtures. It had, no, Miss Mora, I don't care if there was no damage when you bought it. It is a place where a renter has lived for 6 years. There's gonna be holes in the windows, screens. There's gonna, ma'am, when I tell you I am experienced in rental property, not just from being a magistrate, you're trying to put your turnkey cost on the back of the tenant. Yes,
Absolutely not.
And you probably did that before.
Absolutely not.
Yes, ma'am.
Absolutely not.
Yes, ma'am. And she's not required to pay the additional month's rent. You gave her 60 days to move out before an action could take place. She moved before the 60 days, so she's not, you're not entitled to the month's rent. She moved within the time period that you asked her to move.
I'm not disputing that. That's already been established. I'm here because at the time of the move-in, the condition of the unit was not as she left it when she left. And regardless of normal wear and tear, this was beyond normal wear and tear.
Okay. So you said the bathrooms, the cabinets, you had to replace all of those. What else was the most expensive thing you had to do?
The most expensive things were the bathroom, the kitchen, I had to literally do everything. So I don't know where that falls in your
Miss Mara, I'm just not impressed by that, because you bought an old property. The person was already living there. There was already going to be issues because you had a tenant in the place. Every time you bring in a new tenant, there's going to be some turnkey, especially when they've been living in a house that long. You bought a property and you didn't replace all of that stuff when you bought it. So what you're dealing with is a tenant who's already dealing with old appliances, old, and all of that. That's all part of being a landlord, ma'am.
Just because things are old does not justify her messing them up to where now they're inoperable. When we did the walkthrough, those items were not like that. Had those items
did the walkthrough
like
in 2022? It's 2025. Had you been in the property since then, Ms. Moore? Had you been in the property since then?
Say what?
Had you been in the property since 2022?
No, because she never reported it.
Did you do periodic inspections?
No, because she never reported anything.
It doesn't matter. You have the right as the landlord to do periodic inspections. And if there's issues, then you can address them at that time. But if you went from 2022 to 2023, 2024, you never even went back to look to see if there was damages. And you're saying that it should have been pristine from the time she first started living there, or from the time you bought it until the time she moved out.
That's not, I'm not saying that it should have. I just want what's fair.
And I'm gonna give you what's fair. And what is fair, I think, is about $1,500 to $2,000, because other than that, all of that stuff is stuff you had to do anyway to bring in a new tenant. That's the cost of doing business as a landlord. And I also know you're going to take it off on your taxes, because that's how you run a business. So what you're looking at is a double recovery, when these aren't things that you get from a tenant, especially when you're not doing periodic inspections and you can't follow the decline of the property. Now, if you told me at some point you were in there looking at it, but when we're talking about blinds and window screens, that is the cost of doing business as a landlord. And if you haven't ever had to replace stuff like that before, you're not doing it right.
I don't understand. So it's okay for an individual to rent someone's property and purposely cut blinds. That's normal wear and tear. You're telling me that it's okay for an individual to have your dog bite the bottom of someone's blinds. You're telling me it's okay for someone to remove the smoke detector and then it probably can cause a fire due to you not having the installed smoke detector. You're telling me that it's okay for her to have rust at the top of the stove that she supposedly had cooked in. You're telling me that it's okay for her to have rust at the refrigerator?
Ma'am, those refrigerators were old. You don't even know when they were purchased. So rust on a refrigerator, or rust on a stove, you don't even know when they were purchased. So you didn't purchase them.
I seen it in 2022 when I did the walkthrough. It was not like that. That's what I'm trying to tell you.
I don't care. That was 2022. This is 2024 you're talking about.
So you're saying it's okay for her from 2022 to the time she left. That's my stuff.
I'm not going to argue with this. Tenants do all kinds of crazy stuff. I will grant she shouldn't have had a pet. You're charging her the $350 for the pet. I will grant you've kept her to her $775, even though you didn't send her, you didn't update your inspection requirements once she moved out of the property. You set them thinking that she was required to stay in the property, which that makes no sense to me. You give her a 60-day notice and you think on the 60th day she's going to move out on that day into a new place, instead of you're giving her the notice for her to within the 60 days move. Then you didn't update your inspection procedures, an inspection notice. You didn't send a damages report to the last known address. In some cases, she might even be entitled to triple her security deposit because you didn't do it right. Even if you go through the process of doing a damages walkthrough after the person has left, if you're going to keep their security deposit, according to the law, you're supposed to then send the damages report to their last known address. You say you didn't send it, but you're asking me what's fair about a property where you bought it with old appliances in it, you didn't inspect periodically, and you want the court to give you the cost of turnkey. Not going to do that. At this point, I will grant you the $775 and the $350 for the dog. I will grant you the $775 and the $350 for the dog. The rest is the cost of doing business.
So what is the total? You said $775 and the $350?
And you've already gotten the $775 because that was her deposit, and the $350 she'll pay that.
Okay, so can I have that paid? Can you give her a date to have that money rendered to me?
I don't generally do that because it is your job to collect it.
I'll garnish her wages, not a problem.
Once I give a judgment, it is upon the person who prevails to collect the judgment. But Ms. Mora, sit down with an attorney who's knowledgeable because everybody who thinks they know the law, well, I'm doing it by the law, and you're telling me it's month to month when you clearly have a lease that you've negotiated. So sit down with somebody.
Well, this is a lesson learned here in Georgia because it doesn't work like that in California.
No, ma'am. But that's the problem. Everybody comes to Georgia thinking it works like it does up north, where it's no,
right. It
does not.
Well noted.
You can't just come here thinking you know the law. No, ma'am. It doesn't work the same in any other state. Every state has nuances.
Absolutely. I never said I knew the law. I'm not an attorney.
You did. You said I did it by the law. And you said that 3 times to me. When I first asked you what was going on, you talked about I did it by the law. And then you immediately told me you had a month to month and a lease.
Are you going to be able to set a date where she needs to render the money, or do I need to garnish her?
No, ma'am. You need to do whatever you need to do to collect it. I don't collect. I just give the judgment. So $350 for the judgment.
Sounds
all right.
Plan. Thank you.
You're welcome. Take care, ma'am. All right, Miss Lee, you'll pay the $350.
Okay, ma'am. Thank you so
All
much.
right. You're
All
welcome.
right. Bye-bye.
Okay.